So welcome to the Sorensen Center's third Critical Voices from Local to Global session this fall. I'm Camille Massey. I'm founding executive director of the Sorensen Center for International Peace and Justice. And I'm delighted to welcome all of you to this session today. I think it's 11 days and 8 hours and 54 seconds or something until the date, November 3rd. And we are here today, according to US elections projections, at least 47 million people have already voted in the 2020 general election. That's based on data that's populating the Secretary of State statewide database. And so long before election days, voters around the country, many dealing with hardships and barriers and adversity, are lining up to cast their ballots. Projected voter turnout, I was looking about an hour ago, is over 150 million. By comparison, in 2016, turnout was 137 million. And there's a dizzying number of cases playing out in the courts, more litigation anticipated, and who better to help us walk through these uncertainties and the number of questions that we're all asking about what's to come than Jerry Goldfeder and Professor Frank Deale. Thank you both for joining. And we're also delighted to have a recent CUNY alum and a Sorensen Center fellow to moderate this discussion, Christina Das. She is a proud first-generation Indian American and a Brooklynite. Prior to coming to law school, she spent 10 years doing community organizing work and really advocating on behalf of low-wage workers. She's also spent a lot of time around voter protection issues and worked with the Sorensen Center with Adam Edwards and Nora Howe and others on our voter rights initiative that's nonpartisan. In March, we celebrated her election as president of Brooklyn Young Democrats. We're very proud of her, and she'll soon be packing her bags to Ohio, where she's going to work there on voter monitoring efforts. So again, thank you all for joining. And with that, I will turn it over to you, Christina.
Thank you so much, Camille. I really appreciate it. Couldn't have done law school without you, and I couldn't have imagined law school without the Sorensen Center and the remarkable work that the Sorensen Center does for first-generation law students and all of us. So I just want to start off by introducing our amazing speakers. So first, handing it off to Mr. Jerry Goldfeder, who is a renowned election attorney, professor of law, and special counsel at Strzok & Levin. Jerry Goldfeder is a national expert on election and campaign finance law, and he's had a 40-year career doing this work in practice. His name is a household name in election law. Whenever we think about New York State election law, we definitely think of Mr. Goldfeder, possibly because he wrote the book used by so many lawyers and judges today, Goldfeder's Modern Election Law. So really a privilege to be here with him today. He is also the chair of the New York State Bar Association Presidential Task Force regarding scenarios to expect for Election Day and onward. So really excited to pick his brain. So today, Mr. Goldfeder is going to provide us with an overview, a bit of knowledge. He has quite a bit, so we'll see what we can cover in an hour, about the regulatory schemes surrounding the electoral count, the electoral college, what we can expect leading up to January 6th, and also maybe an overview and possible highlights from his recent report that was released from the Bar Association. And for those that want to check out that report, we'll be linking it in the chat box. So I know I'll definitely be taking a look. All right, take it away, Mr. Goldfeder.
So, Christina, I know you by reputation, and frankly, we've not had an opportunity to meet. Good luck to you and the Brooklyn Young Democrats. And Professor Deale, it's good to meet you, although I do think that we met once at my daughter's CUNY Law graduation many years ago. So we each are going to speak for 10 minutes, and then we'll open it up to entertain whatever questions and comments you folks might have. So I'm going to try to speak a little quickly and cover the general outlines, the general parameters of what the way this presidential system works. I do encourage you to look at the New York State Bar Association Presidential Task Force report, because it's pretty comprehensive and detailed, and we're not going to be able to discuss everything today. So the first thing that I want to say is that some people really know this stuff a lot, and some people know it less well. So the challenge always is to try to make sure that I'm addressing everybody's needs in a way that's useful for you. So think of November 3rd, December 14th, January 6th, January 20th. We have a unique and bizarre system of the way we elect the President of the United States. I'm going to start at the end, January 20th. That is the day that the term of the President and the Vice President expires, pursuant to the Constitution. 12 noon, January 20th. Used to be March 4th, but in the 1930s, the Constitution was amended, so now it is January 20th. No, he cannot stay in office beyond that constitutionally. And you can be certain, as I choose to be certain, that if the incumbent loses, the Congress, the Secret Service, the Washington, D.C. police, and the American people are going to make certain in one way or another, in a variety of ways, that he is escorted out of the White House, irrespective of how he may feel about it. Now, I should point out that this is our 59th presidential election. 10 of our elections, the President of the United States was running for re-election, and I should say in more than 10, but in 10 circumstances, in 10 elections, the President lost re-election. The incumbent lost. And in each case, the incumbent turned over the keys to the White House, graciously or not so graciously, but they left. We have a system whereby peaceful succession is our hallmark. And I choose to believe that that will continue, as I say, despite what President Trump and some of his supporters are saying. So keep in mind, so that on January 20th, we will have either President Trump raising his hand or Joe Biden raising his hand, and we will have a new term for President of the United States. Now, November 3rd, you also know what that is, which is the day that is colloquially called Election Day. It's not really Election Day because we have a system that goes back 233 years. It is unique, it is bizarre, but it's exactly the way the founders wanted it, which is to say, we had just fought a war against King George III, and we did not want any kind of autocracy here in the United States. And so we left a lot of the powers in our new government, in our new Republican form of government, to the states. We have a provision in the Constitution that says the states can regulate their own elections. It could be overridden by the Congress, but for the most part, it's not. That's why we have 51 jurisdictions, 50 states, and Washington, D.C. voting for president with all sorts of different systems, different voter ID laws. Some have photo ID, some who do not. Some you just sign your name. We have different laws with regard to whether or not you can vote by mail or you can't, whether you need an excuse to vote by mail or whether you can just do it. A variety of election laws across the United States. And the reason is because our founders put control of our elections, even for our national legislature and for our national leader, our president, in the hands of the state government. So that is why we see this hodgepodge of an anachronistic system where we have different rules in Arizona than we do in California, in Hawaii, New York, and so on. We go to the polls on November 3rd. I said it's not really election day because what we're doing, of course, is we're voting for electors. Electors pledge to Joe Biden, electors pledge to Donald Trump. And that's exactly the way they set it up. And they set it up because they wanted, the founders, they wanted to preserve the rights of the states. And they also set it up in a way to deal with giving preference to the slave states at the time so that they would have more control over the way we elect a president. Many parts of the Constitution relate to the power of the slave states at the time, but it's a system that we continue to have even in the year 2020, despite the fact that it was set up such a long time ago. In the beginning, we had a variety of ways of each state choosing electors. Sometimes a state legislature chose electors pledged to the presidential candidate. Sometimes people voted, as we do now. Sometimes a governor appointed it. This becomes important in 2 or 3 minutes. For the last 145 years, every state has had a law that people will go to the polls and vote for the electors. No more state legislatures, governors picking electors. We go to the polls, we vote for electors pledged to Biden, electors pledged to Trump on November 3rd, or now that we have early voting or through the mails, but the finality of the election period is November 3rd. So at the end of November 3rd, all the votes will have been cast for president of the United States. There's a few states that have runoff elections, but we're not going to address that because the runoffs relate to their congressional campaigns. So at the end of November 3rd, all the votes have been casted for electors in each of the states. And those electors are either pledged to one candidate or another. And then the electors, 5 weeks later, meet. Pursuant to the Constitution, the electors shall all meet on the same day. And Congress set the date. It's the, get this, the first Monday after the second Wednesday in December. And that's the way it's been, and that's the way it is now. So that date happens to be December 14th. So the electors who are voted into office by the people voting for electors pledged to Biden and pledged to Trump, all of them representing their various states in Washington, D.C., will get together in the state capitals on December 14th, and they will elect the President of the United States. That's Election Day, December 14th. And if they do it smoothly, one of the candidates will get a majority of all the electors, which in this case is 270. When you add up all the states in Washington, D.C., there are 538 electors, and a majority is 270. And if it goes smoothly, one of the candidates will have 270 on December 14th. And all of the envelopes with the names of the winning elector, with the winning candidate who the electors voted for, they will be sent to the Congress. And on January 6th, the Congress will open up the envelopes, just like the Academy Awards. And the presiding officer, the Vice President of the United States, will call the roll, starting with Alabama, ending in Wyoming. And each state will say which electors, who they were pledged for, won in their state. And they will ratify, essentially, who's been elected president. And then that person will get sworn in on January 20th. That's if everything goes smoothly. And in most of our elections, everything has gone smoothly. So let's look at one example. Take Pennsylvania as a battleground state, perhaps ground zero of this coming election. They don't have early voting. They do have mail-in voting. And actually, it's relatively new in Pennsylvania. And there's been a lot of litigation all across the country. But in particular, there's been a lot of litigation in Pennsylvania as to the procedures involved in mail-in voting. Believe me, there's going to be a ton of mail throughout the country, but there's going to be a ton of mail in Pennsylvania, of mailed-in ballots. So let's say, because of this ton of mail, let's say there's an avalanche of litigation. And we can expect that simply because there's been already so much litigation in Pennsylvania about the procedures, the election procedures. And they count the ballots, and they fight over, well, does this ballot count? Does that ballot count? Is that signature is it a perfect match to that voter's registration form from 20 years ago? Maybe they don't sign their name the same way, and so there's a battle as to whether or not there's a valid signature on the envelope where the ballot goes. Did they fill in the ballot right? Was the ballot mailed properly? Was it in a timely way? Was it received in a timely way? There are all sorts of issues with regard to the procedure of the mail-in ballot. And then you look at the ballot itself. Did they fill in the ovals or the boxes just perfectly right? Or maybe they circled it, or maybe they checked it. And so we have battles over that, whether it should be counted or not, and litigation over that. Believe me, that if there's 2 election lawyers, there will be litigation. But we will have tons of election lawyers in Pennsylvania battling over these mailed-in ballots. And let's say it goes on for weeks. It goes on for weeks, and it's not clear who won. The state legislature, controlled by Republicans, might very well say, you know, there's no clear winner here, so we, the state legislature, are going to choose a slate of electors. How do they do that? Well, the Constitution says legislatures decide how electors are chosen. Remember I said that sometimes in the beginning of the Republic, legislatures pick the electors, governors pick the electors, people voted for the electors, even though for the last 150 years, people have voted on election day to pick the electors. But there is a statute, 3 U.S.C. 2, if you're taking notes, 3 U.S.C. 2 that says, essentially, I'm paraphrasing, if there's no winner or if you can't figure out a winner, then the legislature can step in and choose and enact a remedy. In other words, choose its own slate of electors. So the Republican legislature can say, we don't know who won. All this litigation going on, it's not resolved. There's no determination as to who won. We're going to choose our slate of electors. Of course, they're going to choose a slate of electors pledged to Trump. Well, the governor, who happens to be Democratic, says, I'm going to veto that. The Republican legislature says, you can't veto it. The Constitution says the legislature shall do it. So there's a real legal issue as to whether or not, when a legislature decides how electors are going to be chosen, whether or not it's just the legislature or the governor has to sign off on it. And they can battle that out and take that to court. So let's say the legislature chooses a slate of electors for Trump, not to be outmaneuvered. The governor, Governor Wolf, the Democrat, he chooses his own slate of electors, of course, pledged to Biden. And they send both of them, both slates, to Congress. And Congress has to decide which slate is the real slate. Are there 20 electoral college votes? That's what Pennsylvania has. Are there 20 electoral college votes for Biden or for Trump? Now, the House is controlled by the Democrats, and we can presume that it will continue to be. The Senate, as we know, is controlled by the Republicans. It's not clear who's going to control the Senate. Well, if the Democrats control the Senate, take control of the Senate, then we have 2 chambers controlled by Democrats, and they are likely to say, oh, it's the Democratic slate of electors that have won those 20 votes from Pennsylvania, and therefore Biden becomes president because he has sufficient additional electors. But if the Republicans continue to control the Senate and the Democrats continue to control the House, then 3 U.S.C. 15, another statutory provision, says, because they can't agree, that the executive from the state could be interpreted as the governor or the secretary of state, whoever that might be. Whoever he or she decides is the winner is the winner. So in this situation, if there is a dispute between the House and the Senate as to which slate is the legitimate state, the governor will decide, and that vote will go to Biden. Well, so that scenario, how likely is that to happen. I'm going to give you one other scenario, and then
then,
I'm
Mr.
going to
Goldfeder, I'm just going to give
conclude.
you a 30-second warning so we can head over to Professor Deal.
Okay, that's
We're
fine. I
getting,
was just about to say I was going to conclude. So
no problem.
we're on the same page there. So let's say there is no winner in Pennsylvania. Nobody can figure out who wins. And on December 14th, the electors from all the other states meet and they vote. And let's say Trump gets 260 and Biden gets 258. And the 20 electors from Pennsylvania haven't been chosen. So instead of 538 electors, there are now 518 electors. And Trump says, I won. And the reason I won is because the 12th Amendment to the Constitution says, all I need is a majority of electors who have been chosen. And only 518 have been chosen because Pennsylvania hasn't gotten its act together. And needless to say, the Biden people are not thrilled with that, and that ends up in court. If any of these nightmare scenarios don't resolve the election, either by the Electoral College or by Congress when the votes are counted on January 6th, and no one has a majority, then the House of Representatives will choose the president. And I think I'll conclude there because I've gone over my time, and I would love to hear from Professor Deale, and we can explore the intricacies of these scenarios after both of us have had the opportunity to present. So with that, Professor Deale, I'm sorry I ran over into your time.
That's okay. That's okay. Thank you so much, Mr. Goldfeder. Very interesting, and obviously various routes that we could see ourselves and at a crossroads. So important to get your insight. So everyone, I just want to give a brief introduction to our very own Professor Frank Deale of CUNY Law. He has extensive experience teaching voting rights, constitutional structures, and civil procedure as well. Here at the law school, he's taught all of those courses, and prior to that, he was a staff attorney, associate legal director, and also the legal director for the Center for Constitutional Rights, or CCR. And there, he carried a large docket of cases litigated at the both federal and state level. And then eventually you can see his name on cases such as Rogers v. Lodge and Butts v. City of New York. So we're really lucky to have his expertise day in and day out here at the law school. So Professor Deale, it's quite possible, as Mr. Goldfeder alluded to, that election night is inconclusive. Postal votes are flooding in. We see that, as Camille mentioned, over 38 million Americans have already voted and continue to vote as early voting continues, and we are dropping off our ballots every day at ballot boxes. So many of us have concerns surrounding the election and also litigation that we haven't seen in our lifetimes, or maybe since Bush v. Gore in 2000. Can you tell us what type of litigation we can expect after November 3rd from either sides of the aisle, especially in this political environment, and also the role of the courts in this type of situation?
Okay, I certainly will talk about those things. And thanks, Christina, for that introduction. And thanks to the Sorensen Center for pulling this whole thing together on such quick notice, because it is an extremely important topic. And Jerry, it's great to see you and hear you talk about these extremely complex matters. I'm glad that was your job and not my job to discuss that. Yes, I want to talk about the litigation which is taking place briefly, because I do think it's important to have a question and answer session. But what is so astonishing to me about this current electoral season is the tremendous amount of voter suppression, essentially almost coming from the top and sort of working its way down. Whoever heard of an election where the President of the United States threatens not to leave unless he is convinced that it was in fact a legitimate election? Whoever heard of a President of the United States basically saying to his followers that they should vote twice, right? Vote once by mail, and then to make sure that you've gotten in there, go down and actually vote in person. These things are sort of really unheard of. And I'm so relieved to hear you say, Jerry, that if this election is in dispute, the main thing is that he's not going to be in there after January the 20th, unless it ultimately turns out that he has in fact won legitimately. That's a very, very important point for all of us to hear and really to keep in mind. But my observations about the litigation going around, not so positive, at least in terms of the cases that have been going to the Supreme Court of the United States. We get a chance to talk about these cases in my voting rights class, and a number of them that I could make some reference to, but I think the one I want to just say just a little bit about is this extraordinary situation which developed in the state of Florida, where, as you know, there was an election, initiative election, where the people of Florida overwhelmingly voted to essentially re-enfranchise people who were convicted of crimes. And shortly after that amazing ballot took place, the governor essentially went to the state Supreme Court to essentially try to knock out the consequences of that victory. And sure enough, the state Supreme Court put in place a ruling which allowed the state legislature to follow up and say, well, you know, you really can't take advantage of this, you former felons, unless you pay all the fees and things that you essentially owe as a consequence of your being convicted. I mean, jail fees, restitution, things along those lines. So there was a very, very important trial which took place where the trial judge came in with an overwhelming decision, basically concluding that there were all kinds of problems with the idea of these folks having to pay these fees. But sure enough, that victorious decision was stopped by the Supreme Court of the United States, in a decision which, you know, very much reflected partisan political party lines. And that's kind of what we're seeing in so much of this litigation, which gets to the Supreme Court. Two things I really want to focus on. First, the court tends to utilize this fairly new principle, sometimes referred to as the Purcell principle, right? It kind of uses that to essentially keep the federal courts out of adjudicating certain types of voting rights claims when it's felt that the decision of the federal court is coming too close to the actual election. And what the court has said in these situations basically is that we're going to knock this decision out because it has the potential to essentially confuse the voters, right? That's the signal which has been coming out, and that's been damaging in a number of cases, not just the one that I was talking about from the state of Florida. The other thing that we're sort of seeing in these cases, as I mentioned before, is this tendency to have a partisan political lineup. And I see this as something which is going to be exacerbated going forward if it's expected. Seventh Circuit Justice Barrett essentially takes her seat on the Supreme Court of the United States. And I think that presents amazing problems because, you know, she will be the fifth Republican on the court. And if she adheres to a strict party line, like four of the other justices have done, I think that is a bad sign for continuing litigation taking place as we get closer to the actual election day. So those are two problems that we've basically seen already. But there is a third one, which actually made itself manifest in a decision in a case coming out of Pennsylvania that Jerry alluded to, a case where the Pennsylvania Supreme Court actually extended a deadline for the receiving of and counting of absentee ballots because of the pandemic. And the legislature essentially took the case of the Supreme Court of the United States to try to get the Supreme Court to overturn that Pennsylvania Supreme Court decision. Well, what happened was that the Supreme Court basically split 4-4 because there was that vacant seat, which is still there. And that appeared to be a victory for the Democrats in that particular case. But if you kind of look at it more closely, I think there's some problems sort of lurking underneath the surface. That was kind of an extraordinary case because you have a situation where the Pennsylvania Supreme Court essentially ruled to extend voting rights, but the legislature essentially, went to court saying that the decision of the Pennsylvania Supreme Court had the effect of taking away their powers under the state constitution to essentially declare what the rules should be for particular elections. That state power is essentially guaranteed by the elections clause of the federal constitution. So even though it was a 4-4 split vote, what was so interesting to see was 4 members of the Supreme Court apparently wanting to exercise review over a state court decision that was primarily about state law, right? An interbranch dispute between state factions in the Pennsylvania legislature, essentially coming within the Supreme Court's power of judicial review because one of the parties invoked the elections clause of the Constitution. What that signals to me essentially is that during this election season, we might see a broad range of judicial review by the Supreme Court over some of these cases in situations where you would normally not think the court could in fact exercise review because you have state court decisions about state law. So I think that's something to keep your eyes on. So basically looking at the litigation about individual rights and the whole plan of making individual votes count, notwithstanding what's happening in the lower courts, which seems somewhat positive, the Supreme Court seems to be a big sign of trouble. Now, I want to talk about the other kind of litigation, which hasn't started yet, but it certainly can emerge in light of what Jerry was saying about the Electoral Count Act, the 12th Amendment, and all the ambiguities in terms of that statutory and constitutional scheme. However, looking at those provisions, what seems to be the case to me is that any litigation which comes to the federal court to try to work out disputes that may come up from that complicated process seem to me to be arguably political questions, which may in fact keep the Supreme Court out because of the court's political question doctrine, which we saw put in place just recently in the court's decision to essentially no longer adjudicate political gerrymandering cases. And actually, I think that if in fact those cases coming out of that process are considered political questions, it may not be such a bad thing. Because as I said before, I think Barrett will be on the court by that time. The political breakdown in terms of Democrats and Republicans will be even more solidified in terms of the Republican Party. I think the fear, of course, is that you have a court that it's so biased towards these questions that the court might feel some sort of a victory from a lower court regarding something that helps Joe Biden is something the court can adjudicate, where something that benefits Donald Trump is something which should be written off as a political question. But I think that the likelihood of a lot of litigation coming out of that complicated process seems not so likely to me, because after all, it just seems like these provisions really work out a political mechanism for deciding these types of cases. And to me, that necessarily means that the court really should be staying out of it. And as I said before, that is a good thing. The other thing which I think could be positive, and this again sort of picks up on what Jerry was saying, if these disputes actually go to the Congress of the United States, the House and the Senate, I find it refreshing to know, I may be wrong about this, but I find it refreshing to know that they will be worked out by the new Congress, right? And not by the old Congress. And sort of taking a look at the scenario around the country, it seems to me that if you sort of can get on top of this voter suppression, it seems like there's a good possibility that we could have some large swings, which could make it a good thing to essentially have the political branches working out these disputes if in fact there's a wave that allows the Democrats to essentially take over the Senate. I'm not so not optimistic about the litigation which is taking place. I think the key thing is to try to keep these cases away from the Supreme Court to the extent that that is possible. But I think when it really comes down to the nitty-gritty of it, if in fact this election gets thrown into the House and the Senate, I'm hoping it will have a massive blue wave so that people making those ultimate decisions will in fact be Democrats in the House and the Senate and not the Supreme Court of the United States. Right. So having said that, I hope we can have a nice, productive Q&A session.
Thank you so much, Professor Deale. That was really important. Thank you so much for your insight. So moving on, we will turn to a Q&A. I see that we have a bustling chat going on. I'm just going to ask one question in my capacity as moderator, and then we will definitely switch to our participants, and we will unmute you to allow for an interactive process. So if you've written your question in the chat, please be ready to unmute so that we can hear from you directly, and definitely let us know if you're a Sorensen Center alum as well. I see several of us are here and present as we usually are. So the first question being, I think I'm going to ask this to Mr. Goldfeder, is, you know, you highlighted the process for election day and how we will be electing electors, basically. Although president and vice president candidates will appear on our ballots, essentially voters are going to be electing members of respective electoral colleges. So are these electors essentially party loyalists? Are they free agents? Can you talk to us a little bit more about the so-called faithless elector? And for those that don't know, in 2016, we had an unprecedented number of faithless electors or deviant electors, those that did not vote in line with the party, but then voted against the party line, about 10, which was higher than any election in the past 58 electoral cycles that we have had for presidential races. So Mr. Goldfeder, if you could just speak about faithless electors quickly, and then we can turn to our Q&A from the audience.
The Constitution doesn't prescribe as to who is eligible to be an elector. It proscribes that a member of Congress can't be an elector, or somebody who works for the federal government can't be an elector. So who are these people anyway? They are party loyalists. They are donors. They are friends of the presidential candidate or friends of the governor in a particular state. And they can be expected, and they have complied probably about 99% of the time throughout our history. Electors pledge to a particular candidate, whether informally or formally. They're party people. And so they vote for whoever wins in their state because they pledge to do so either by law or by political culture. Sometimes, as you say, an elector will decide to vote their conscience. We can characterize that as a faithless elector. We can characterize it as a faithful elector, faithful to their conscience. They've done so very few times in our history, and they have never made a difference in terms of the outcome of the election. And as you pointed out, in 2016, there were 3 electors there were a number of faithless electors, 3 of whom came from Washington, and there are 32 states that require electors to vote for whoever won in the state. 18 states say don't have a law. In fact, New York doesn't have a law. So theoretically, we can vote for whoever we want as electors in New York. But since we're party people, we do the right thing, whoever wins. But in the state of Washington, if you vote against your party, we're going to fine you $1,000. And they were fined $1,000. They never paid, but they were fined $1,000. Anyway, this went to the Supreme Court of the United States, and the Supreme Court just recently ruled that states can bind electors through statute. And what happens is sometimes they are automatically removed by operation of law, and someone who is faithful will be put in their place, or they can do as they see fit, but they might be fined, or worse, prosecuted. But as I say, I don't think we really have to worry about this, famous last words. I don't think we have to, because they've never had an impact in such a way as they've changed an election.
Christina, can I say something about that too?
Of course, Professor Deale.
I think that I don't know, I like Jerry, I'm not so concerned about the whole question of faithless electors. I think it can kind of go either way, you know, so to speak. And some of you probably know that there is this campaign which is going on. I forget, there's a New York Times writer who I think is kind of behind it. And he has this idea that, you know, first of all, you need to get rid of the Electoral College. But he points out that since that's not going to happen anytime soon, maybe the way to sort of deal with the problems presented by the Electoral College is to, in fact, have states, legislatures pass laws saying that the electors, instead of pledging to vote for some candidate beforehand, they should essentially pledge to vote for the candidate who gets the largest, who gets the national vote. That's sort of a strategy to essentially assure that we don't have situations like we had with Hillary Clinton and Al Gore, where the president of the United States wins the election by essentially having a minority, a small percentage of the popular vote. As a way of dealing with that, if the electors just pledged to vote for the person who got the most votes nationwide, that would be a quick way of essentially being able to deal with the Electoral College without having to have a constitutional amendment. Now, that's state legislators doing that, if in fact they make that decision. But an elector could always do that, right? A faithless elector could say, well, I'm not going to vote for Donald Trump, even though he won the votes in Ohio. I'm going to vote for the candidate who got the most votes nationwide, because really the person who got the most votes nationwide should really become the president. So, the whole faithless elector thing, I think, points in two directions. I think the real question, of course, is with the Electoral College and how to get on top of that.
Noted. Okay, thank you so much for that. So I'm going to turn now to our audience questions. And I think I saw a question by Lawrence Alabaster. Lawrence, are you still in the session? And we can go ahead and unmute you, and so you can ask your question.
Sure. Yeah, I was actually asking a question about Roberts. But I think the more pressing question for me would be, do we anticipate a possible situation like the hanging chads in Florida, where particularly in this election when it's going to be a mail-in ballot, and my concern is in the Bush v. Gore case, the Electoral Commission was primarily made up of people put in place by Jeb Bush, and then belonged to the GOP. And I guess having seen some recent elections in Georgia where the Secretary of State purged the electoral rolls for an election that he was standing in, is there anything that we can do, or that lawyers can do, or the Democrats can do to stem any possible problems that might occur with Florida, particularly when Florida is going to be such a battleground state?
Florida, always causing us problems. All right, take it away, either Professor Deale or Mr. Goldfeder.
I'm saying he should, and he's saying I should.
Okay, so I'll go ahead and pick.
I'll say that we don't have any hanging chads any longer, because they did away with that form of voting. But what we do have is people filling out ballots, and people fill out ballots in all sorts of ways. As I said before, you're supposed to fill in the oval or the box, but not everybody does that. Sometimes you circle it, sometimes you check it. And the machines where you feed your ballot into these machines, they operate by lasers. So a certain portion of that oval or box needs to be filled in for the machine to see the vote. And if you just kind of check it or circle it, the machine won't see your vote, and therefore it won't count. It's what we call an undervote. So I expect, if there are close margins in any particular state, and we face that situation, I expect litigation to occur as to whether or not there should be what we call a manual count, a hand count. Let's look with our own two eyes at each ballot in order to ascertain whether or not the person voted properly and who they voted for. And as I say, it really depends on the margin. If the margin is close, we can expect that kind of litigation. And both sides have lawyers in most, if not all, of the states, certainly in all of the battleground states. And we can expect that kind of fighting to go on before the administrative agency, the Board of Elections, and then in court if necessary. And the last point I want to mention is, you are right that boards of elections are constituted pursuant to the statute of the state, and very often they are partisan, and therefore these decisions will unfortunately become partisan decisions. And that's why we can expect a long drawn out, if the margins are close, a long drawn out litigation over counting ballots in both state courts and federal courts. And even though Professor Deale is right that generally speaking, it's state laws that control, there are equal protection problems and due process problems that can be raised in federal court, and that's what Bush did. So I think we kind of can expect litigation in both state court and federal court over the way people actually fill out these ballots.
Yeah, so much of the litigation which has been happening thus far has been around questions, for example, where states want an absentee ballot to be notarized before it is in fact, sent in, right? Which presents serious problems during a pandemic because people don't want to have to leave their house to see a notary. They want to have somebody come to their house to witness the signature that they actually put on the ballot. Now, where I am, we didn't have to, go to a notary or have a witness, but we still had to sign the ballot. And I can certainly imagine in certain situations where a notary or witness is not required, struggles taking place matching the signatures, right? Is a signature on the ballot the same signature that is in the books that you would normally, sign when you actually go down to vote in person? I can imagine a huge range of cases like that essentially hitting the courts and really slowing the process down, basically taking you to some of the problems Jerry was talking about with these deadlines that are really important.
Absolutely. And keep in line with the theme of Florida, as well as potential litigation, I'm going to turn it over to fellow Sorensen alumni here, Jerry Milan, who had a question dealing with what's on everyone's mind, the Supreme Court nomination process, confirmation hearings, and take it away, Jerry. Let's hear about what could potentially happen with Judge Amy Coney Barrett.
Thank you, Christina. I am on mute already, right? Okay. Hi, thank you, Mr. Goldfeder, for sharing your insights, and Professor Deale. I still love civil procedure because of you. My name is Jerry Milan, and I'm a CUNY Law student and a Sorensen Center Fellow. I have a threefold question, which I was told is impermissible, so I'm going to pare it down to one. But it would be great to hear from both of you about this. So I'm just going to read my question that I already posted. So according to CNN, Judge Amy Coney Barrett, once confirmed, will be one of the 3 current Supreme Court justices who assisted the legal team of then Texas Governor George W. Bush in the Florida ballot recount battle that came down to a single vote at the Supreme Court in the Bush v. Gore case, along with Chief Justice Roberts and Brett Kavanaugh. So I have 3 questions there, but I'm going to ask, and I'm going to ask this question instead of going to the 2. Do you think that part of the motivation for to push for Barrett's confirmation is to lay the groundwork for a potential Bush v. Gore-like case before the Supreme Court? And as I guess everyone noticed, they're kind of railroading the confirmation.
Yes.
Yes, that's it. That's all we got from Mr. Goldfeder. Short and sweet. Anything else, Professor Deale?
He was explicit about it. I mean, they were from the moment Ginsburg died, right? They were explicit about getting a nominee on that court before the election took place. So I have that was part of the game plan.
Right. It's pretty clear. Americans aren't stupid. We see what's going on. So I'm going to move on quickly to just keep track of time to another Sorensen Center alum and fellow voting rights organizer, Adam Edwards. Adam, please let us know what's on your mind.
Thanks, Christina. Yeah, I mean, I'm sure we've all seen, snippets in the news about different, instances of voter intimidation going on, some, much more intimidating than others. But I think the other thing is that we're all kind of just expecting in horror about, what would happen on election day, especially because Trump is strategizing by having apparently hundreds of thousands of people volunteering and training to go to polling sites and intimidate people. They're openly doing that. I mean, if he were to win the election and there was evidence of widespread intimidation, I mean, it just seems like the election would be seen globally as illegitimate. based on that. I mean, voter suppression would be really bad, but people would just kind of begrudgingly accept the results, probably. But if people were literally like being shot at or all kinds of crazy scenarios, um, that to me is the most concerning thing, because if it's seen as illegitimate, I mean, I just don't see how the country survives politically, or like it's very hard to cohere. Um, so I know that there's a couple lawsuits going on about this, but I don't know. I haven't really seen anything yet that would have has the potential to have an impact on preventing that from happening. And I'm wondering if there's any kind of insight either of you have about what could be done, what should be done, what the laws are around this.
Well, if I may, thanks for asking that. I actually, I'm really deeply concerned about that issue, probably more than any other issue. We've already seen thugs at early voting sites. We can call them lawyers who are poll watching, but we can also call them thugs, because there are a lot of non-lawyers and there are lawyers acting to suppress the vote. And there are laws in place. In fact, I want to say it's Georgetown Law Center put out a report of the laws in each of the 50 states and Washington, D.C. relating to laws that prevent intimidation, harassment, suppression, and so on. But those are the laws. But what do people do if it's actually occurring? Well, one of the things is that we have enough lawyers there to try to stop it. There are police and sheriffs who are at the polling sites legitimately because they're required to be. Some of them act independently and pursuant to their jobs, and some of them are become caught up in the thuggery, if you will. I'm being blunt about it. So there's a limit, though, to what lawyers can do if people are intent on causing a ruckus and intimidating people, and as a result, suppressing the vote. So I think what needs to be done is what's being done in Detroit and some other places. In Detroit, not for the first time, we have members of the clergy going to the polls and hanging out, making their presence felt, wearing their collars, to have a presence in order to forestall that kind of illegal actions by people who want to close down polling sites. But regular Americans ought to do that as well. We should really make sure that we mobilize to allow people to vote and to have our presence felt, to make people feel as safe and as encouraged to vote as possible. It's really in our hands if to do that, to have a presence. So there's a legal piece and then there's a mobilization piece. And I think both are really necessary because of this very real threat to our Republican form of government.
I think that the problem you put your finger on, Adam, is the key problem. And I think that what exacerbates it is the way that the police forces and police unions have come out, so vigorously in support of Trump. I mean, you sort of get the idea that if, Trump thugs kind of come out to the polling site and start harassing people and intimidating people, the people who you mostly think you would have to rely upon to sort of stop that are your local police. I mean, those are the folks who the election officials are going to call if, in fact, folks show up with guns and things like that. But how are the police going to respond, right? I think that's what makes this such a traumatic possibility working itself out. So I don't pretend to know the answers to those questions. I think that if push comes to shove and people are outraged about it to the extent that they were outraged about what happened to George Floyd, then people are going to hit the streets. right? But of course, there you're in confrontation with the same police forces that, we've seen acting in Portland and other places. So, all I can hope for is that there is not just a victory for Joe Biden, but an overwhelmingly undisputable victory for
Right.
Joe Biden, because that's
Right.
the only way that we could be assured that those forces, in fact, will be repressed and discouraged from coming out and engaging in intimidation, both before the election, during the election, and after the election.
Right.
Right. I agree with that. I think just recently we saw in the news that Alaska and Florida voters had been intimidated by email by Trump supporters, and there has been sheriffs mobilizing in front of the polling sites. So definitely things to look out for. And just a plug for more of us to get out there and work the polls and also do poll monitoring. You don't have to be a lawyer to do that. You can observe the polls just as an everyday citizen. And then I know it is close to our closing time, but I have one more pressing question from another Sorensen alum and another active voting rights activist here, BJ Steiner. And so BJ spent a lot of time working on local election laws and also working at NICLU. So BJ, take it away and let's wrap up with your question and then some closing remarks.
Hey, everybody. I have a question. So recently, there's been a serious call for the Democrats to expand the number of seats on the Supreme Court in the light of Amy Coney Barrett's impending confirmation to the court. Given recent decisions on voting rights that can be somewhat charitably described as dangerously partisan, striking down any attempts to expand voting access in the light of the pandemic and upholding any attempt to sort of suppress the vote, sometimes on propositions that directly conflict with each other. Do you think court expansion is a viable option to protect the right to vote, given the possibility we might have a 6-3 court that is to the right of the author who wrote the Shelby County decision? Your thoughts?
Well, it's not going to impact this election. Biden today said that he is going to set up a commission to study the issue, which is progress because up until today, he didn't say one way or the other what his position was, although he did intimate that he was an institutionalist and he wasn't crazy about the idea. I'm not crazy about the idea either, but it's not just her. It's not just Barrett. It's Merrick Garland, what they did there and what they're doing now. And I think that setting up a commission is a good idea because there's a variety of ways of dealing with it. The original court packing plan of Roosevelt was to put somebody in, put another person in once somebody turned 70. In those days, 70 was really old. I don't think so any longer, but in any event. So there are a number of ways of dealing with it. Pete Buttigieg, I happen to have been his campaign lawyer. He had a set of proposals relating to limiting the term. So there's a number of ways of doing it, but the long and short of it is not a legal answer, is a political answer, which is to say, Republicans play hardball. Democrats have to play hardball because we're watching them, the other side, do whatever they want, no matter what. And the Democrats really need to take hold of the situation to try to even it out. And I hope that comes to pass.
Absolutely. Let's put on our boxing gloves. All right, Professor Deale, do you have any last remarks?
Yes, just the last piece on this question. I don't agree with everything that Joe Biden says, but I think he's handling this one pretty good. The Ronald Reagan Solicitor General of the United States named Charles Freed just wrote a piece in the New York Times, made a very interesting observation. He said, under circumstances like this, maybe what you should do is talk it up and see. Talk it up and see. You watch and see how the court acts while this discussion is going forward. And if you begin to see reversals of longstanding precedent, that's when you essentially take your move. It's a good idea to sort of talk it up because, Roosevelt never put his plan through, but he talked about it enough. He had enough people talking about it that he got that one vote that he needed. right? That one vote by the infamous first Justice Roberts, right? That's all he really needed to make the change. And that was just by talking it up and making it seem like a possibility.
Yeah.
So from my perspective, if you talk it up and make it seem like it's real, maybe the court will get the message, right? And they will back up a little bit on any plans that they have to really start overturning 50 years of litigation.
Exactly. Absolutely. All right, everyone. I know that we are a bit over time, but thank you so much again, Professor
Thank
Frank
you.
Deale, Mr. Goldfeder. Thank you so much. Such a pleasure to be in your company, and thank you for sharing your resources and being on the front lines of democracy as always. We have to stay united together because democracy is really what's on the line. And again, thank you to the Sorensen Center, to the CUNY Law Review, near and dear to my heart, both co-sponsors of this event. Our partners at Breakthrough are here today, the organization that I worked with when I was in India as a Sorensen Fellow. And again, just stay tuned, and October 29th, we'll have a voting rights symposium hosted by the Law Review. You can come and ask your questions there. We'll have a whole host of experts from NYCLU to the Brennan Center for Justice to Democracy NYC. And so keep continuing the conversation. Make sure you head to the polls. If you're in New York, early voting starts on Saturday, October 24th until November 1st. And then if you're not in New York, tuning in remotely, make sure you go to iwillvote.com and look up your state and also your respective voter laws, absentee ballot drop boxes, and make sure to check if you can vote early. So get out there, stay safe. Thanks, everyone.